Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us, coming to you from Washington's premier indoor shooting facility. Of course, that's Security Gun Club right here in Woodinville, Washington. Yeah, we've been doing videos here all week. Why is that? Because we are transitioning over to a new studio to give you better quality videos. Now, we got to talk about a really loaded topic here, America, and that is, should illegal aliens be allowed to possess firearms? That is, does the Second Amendment actually protect illegal aliens, undocumented individuals, newcomers, whatever the nomenclature and euphemism is we're using now? We know that these people have started their journey to the United States by illegal activity. So their very first act of being a resident of the United States is in fact illegal activity. And this has led to a big debate in the 2A community, and it's led to some cases out there that are now challenging the federal prohibition against this. The problem is that the United States government is getting pretty desperate with its arguments, and I want to tell you, they're making some very dangerous arguments here, and that's what's got me spooked. And so I'm going to try to get you educated, because you do need to watch this issue no matter what side of the decision-making matrix you come down on. So today, let's spend a few minutes and let's talk about the incredibly dangerous arguments in favor of disarming illegal aliens. Okay, before we get going too far down the road we're going down, proud to announce that this video is being brought to you by Right to Bear. That's right, legal protection for self-protection. Listen, good lawyers aren't cheap, cheap lawyers aren't good. You're not truly prepared unless you have Right to Bear back you. You will always get an attorney-answered hotline, so you will always have a confidential phone call. There are no cap limits for either civil or criminal defense. This covers all forms of self-defense. So from a fist to a firearm, from a fat lip to a dead body, you are covered, and you will have some of the nation's most passionate 2A attorneys in your corner fighting for you. And right now, if you visit my friends at protectwithbear.com and you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com. Okay, America, this is the case we're talking about. We're talking about the case of United States v. Jose Paz Medina-Cantu. It is a case that is filed currently in the Fifth Circuit, and it is a challenge to 18 United States Code Section 922 G5A, which is this portion of federal law that prohibits undocumented aliens from possessing firearms, or essentially says the Second Amendment does not protect you. Now, we have seen a tapestry of cases. We actually did this video right here where a judge in Illinois, an Obama-appointed judge, said, nah, this law is unconstitutional. There's no historical tradition. Now, that set off a huge spark of debate amongst the 2A community, and it is a tough issue. It is a tough issue here because many of you believe that our Second Amendment rights were actually given to us by our Creator, and what the Second Amendment merely states is that government can't take it from you. Well, if that's the case, do we honestly believe that the Creator only bestowed those rights upon those that He created in the United States of America? I mean, it's a loaded question. We're not going to go down that road today. Instead, what we're going to do is we're going to go down the road that the United States Department of Justice is taking here, because they are coming up with some really scary arguments. And listen, I'm not in favor of allowing illegal aliens to possess firearms. I have a hard time believing that they are part of the people as contemplated in the Constitution. We're not going to get into that today either. What I'm most concerned about, though, is that the arguments the United States Department of Justice is making here, well, if those fly here, they could start using them for a lot of other groups of individuals, and that is what is most dangerous. Now, so you understand, one of the old cases, which is in the way here, is a case that also came out of the Fifth Circuit, United States versus Portillo Munoz. Now, that case was decided all the way back in 2011, and so it was not done under the Bruin analysis. But as the Department of Justice points out here, that may not make a difference, and we'll get to that in a second as well. Okay, so the context of this is that the Fifth Circuit had asked for a memorandum on supplemental authorities as to how Rahimi may have changed the court's inquiry as they're sitting on this case trying to decide it. What the United States Department of Justice is basically saying is hey, you know what? Rahimi didn't change anything. In fact, if anything, it just endorsed what we're doing here. They specifically state, Rahimi did not undermine this court's prior holding that 18 U.S.C. Section 922 G5A is constitutional under the Second Amendment. In Portillo-Munoz, this court determined that the protection contained in the Second Amendment do not extend to illegal aliens present in the United States. This court explained that the people protected by the Second Amendment refers to a class of persons who are part of a national community or who have otherwise developed sufficient connection with this country to be considered part of that community. And I think a lot of us could actually begin to get on board with those arguments. And so when you first start going through this memorandum, hey, the arguments seem to be pretty middle of the road arguments, kind of applying the law, but don't worry, they're going to get a little bit out of control. Now, the United States Department of Justice basically believes that the government can do whatever they want to illegal aliens. Don't believe me? This is what they wrote in their memorandum. The Supreme Court has long held that Congress has the authority to make laws governing the conduct of aliens that would be unconstitutional if made to apply to its citizens. Nothing in Rahimi undermines this court's reasoning. To the contrary, the Supreme Court in Rahimi emphasized what its prior precedents observed. The Second Amendment extends to ordinary citizens. Okay, and this is what I want you to begin to start worrying about. Don't worry, it's going to get a lot worse than that. But what exactly is an ordinary citizen? Because the Department of Justice has a tendency, as does the ATF, by the way, to change their mind as to what words mean on a frequent basis. Now, what the plaintiffs are arguing here is, hey, listen, Portillo-Munoz, the old precedent, decided in 2011, used this two-part balancing test, okay? And Bruin has thrown that out, and so therefore, it's really no longer good law. The Department of Justice says, hey, listen, a look at historical analogs is only necessary if you believe that the Second Amendment covers the activity in question. What the Department of Justice is saying is we don't have to get into a historical inquiry here because it's pretty obvious that the Second Amendment does not protect an illegal alien as they are not part of the people. Because, as Portillo-Munoz discussed, the Second Amendment's plain text does not cover unlawfully present non-citizens, this court did not need to assess whether Section 922G5 is consistent with history and tradition. And so, in concluding their reasonable arguments, the Department of Justice points out, the government maintains that illegally present non-citizens are not covered by the Second Amendment because they are not among the people, which, as Heller and Bruin explain, refers to Americans and members of the political community. Okay, so far so good, but now here's where we're going to take the big left turn and drive the car off the roadway, because then the government goes from what is anticipated arguments to some pretty scary stuff, and they start it this way. Even assuming the Second Amendment's text covers illegally present non-citizens, Rahimi supports the government's position that disarming illegal aliens is consistent with our nation's historical tradition of firearm regulation. And you sit there and you go, what? Okay, so illegal aliens are, by their very nature, dangerous individuals. Some of them are, there's no doubt about it. We have to pick up the paper every day and determine that. Many of them are not, though. I should also point out that there are many jurisdictions in the United States that are willing to allow these people to vote. There are even some jurisdictions that are looking to allow these people to actually work for government positions, including law enforcement. Yet the Department of Justice wants to claim that every single one of them is dangerous. But the way they get there is the way that I told you it was going to happen, which is they're going to take all of the sloppy language in Rahimi, and there is plenty to work with, and they're going to say, hey, you know what? Close is good enough. We had a regulation over here that regulated apples. I know we're trying to regulate oranges. They're both fruits, so hey, close is good enough. Don't believe me? This is what the United States Department of Justice wrote. The court emphasized that even when a challenged regulation does not precisely match its historical precursors, it may still be analogous enough to pass constitutional muster. The law must comport with the principles underlying the Second Amendment, but it need not be a dead ringer or a historical twin. Rahimi therefore confirms that specific historical laws may reflect broader principles that can be applied to uphold modern firearm laws. Did you catch that last sentence? That last sentence is one of the most dangerous rules of law that any court could ever possibly adopt. But guess what? The Department of Justice is not done there. Section 922G5A is constitutional under this nation's historical tradition of firearms regulations as well. First, there is abundant precedent before, during, and after the American Revolution for disarming individuals who were not members of the political community. Second, there is a historical tradition of disarming untrustworthy adherents of the law. Standing alone and in combination, these regulatory regimes and historical traditions are relevantly similar to Section 922 G5A. Untrustworthy adherence to the law. Can you imagine if that becomes the standard by which government can disarm you? And perhaps the scariest statement in this entire memorandum of authorities is this: Rahimi did not undermine the government's substantive argument that history and tradition support the government's authority to disarm categories of individuals whose firearm possession poses a risk of harm to others. Now, we know about how the justice system has been weaponized against people. We know how mainstream media and electronic media is also doing the same thing. If we are going to allow these watered down standards, which the Department of Justice is proposing here to be a basis by which we can disarm Americans, we are headed for a period of time in which there will be arbitrary and capricious disarmament of large swaths of American population for no reason other than political disfavor. Historical laws disarming groups because they lacked membership in the political community or who were unwilling to comply with the law are sufficiently similar to Section 922 G5. Under Rahimi, that is enough. So listen, I get that this is a really, really loaded issue, and I get where most of you come down on it. And I am not saying for 1 second that the Department of Justice doesn't have some legitimate arguments here, and that it is highly probable that illegal aliens are in fact not part of the people and therefore not protected by the plain text of the Second Amendment. However, the Department of Justice has detoured here and gone into an area that is incredibly scary, wrought with problems, and could ultimately lead to the disarmament of many other segments of American population. We're going to go ahead and link up the memorandum of authorities down below so that you can geek out on it for yourself. Maybe you got questions about this or something else related to what's left of our Second Amendment rights. So you guys should know how to get a hold of Washington gun law by now. If you don't know how to do that, that's okay. That information's down there in the description box. Maybe you got an idea for a video we should be doing here. If you do, click on that link right there. Maybe you just want to subscribe to our newsletter. Hey, the information on how to do that is down below in the description box. And then finally, and most importantly, let's everyone remember, a part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.